Hello, Prince Edward Islanders. I'm Jacinta Gallant,
And I'm Taylor Smiley.
and we're from Waterstone Law Group in Charlottetown. This is an unprecedented time in our world, on our island, and it's particularly difficult for families who are separated. You're worried about your children, you're worried about family members that perhaps you haven't seen in a while. Many of us are isolated in our own homes. We want to support Prince Edward Islanders by ensuring that if you have burning questions about family law or even about family conflict, you can come to this video and we're going to do our best to answer your questions and to provide you with encouragement and we hope some hope. Waterstone Law Group in Charlottetown works in mediation, collaborative practice, and in negotiating where families need some attention paid to the relationships they want to carry on. We want to remember that right now is a very stressful time and that we have to both consider our own situations and our families, but also to remember that there are people in the world, in our communities, who still need to leave their homes. And that together, it's almost like a global deep breath, that we're going to stay home to help the most vulnerable among us to stay safe. Now, Taylor and I can't treat the sick. We're not healthcare professionals. We're not working to supply or clean the very important things that we need in our community, but we are lawyers, though Taylor, who was to be admitted to the bar in 28 days, I think, they'll have to delay becoming a full-fledged lawyer. So being lawyers, we do have to point out that we've invited you to send your questions to us and we want to be helpful and informative. Because we're not addressing very specific legal situations, this can't be considered to be legal advice. And it doesn't create a relationship between you and our firm that would be qualified as a lawyer-client relationship. We received your questions anonymously and we have changed some of the information so that it's easier to preserve your privacy and confidentiality. So you'll see, if you submitted a question, you'll likely see that there's some changes to it so that we can ensure that everyone feels that their confidence is being kept. Taylor's going to read the questions and I'm going to do my best to answer. So let's go.
All right. Question number 1. So the situation is this. The parents are in joint custody. Both parents work in essential services and are leaving home to work. The kids are with their dad every second weekend and for one overnight each week, and the kids are with their mom the remainder of the time. The mom has recently learned that people who are supposed to self-isolate after returning to PEI have been to the dad's home. She has some worries as she works in healthcare and needs to be careful about exposure to sick patients and to the children at home. Some of the kids in their family have asthma, which is also a concern. Dad has not agreed to close his home to anyone but the children and his current partner. He wants to include another child who is supposed to self-isolate and also living at his home. The dad is worried about missing time with his kids. So their question is, what can they do?
So this question keeps coming up. And I'm afraid there's no easy answer. One of the things that you have to keep in mind is that as parents, we are required to protect our children. And right now, the rules around protection of our children would include following the guidelines of our chief medical officer and the guidelines that have been issued nationally. And that is that if someone's returned to Prince Edward Island, they need to self-isolate, whether they're a child or an adult. And so these are difficult choices. Perhaps the dad in this situation is bringing a child into the family for many, many, many good reasons around comfort and connection. And the problem is that it would be against the rules for someone who's required to self-isolate to then spend time in a home with other family members who do not need to self-isolate. The challenge in this case may be also around mom and dad not being able to agree. So the challenge isn't always, what do we do? Like, what's the answer? the challenge can be also, how can we figure this out in a way that ensures both parents have strong relationships with the children, and that the children have the connection with both parents that they need in a kind of a scary time. So I'd recommend, in terms of how you do this, that you try really hard to use the guidelines as your rule, because that will give you an answer to the question right now. 14 days isolation, no exposure to children. But the other problem is, you've got one person who goes out to work in healthcare. I thought that was a really important element of this question, so we included that in the publicized version of the question, because you've got a couple of worries. You're worried about your own exposure by being with patients and being in places where people are sick. Also worried about bringing that home to your own family. And so you can see how the mom in this case has these worries that have to do with very much the occupation that she's in. Equally, dad is no doubt missing time with kids, especially when it is a scary time and both parents want to be there to support the kids. So I'm going to suggest that first you have to follow the rules. There is no question about this. The children cannot go to a home where someone who was supposed to self-isolate has been. And that would be for at least 14 days. You need to stay up to date with what the rules are, because of course they are changing. And so it's important to always be following the latest information that's been provided by our Chief Medical Officer in Prince Edward Island. There's some other things that you can do though. You can, if you're really struggling as two parents trying to make a good decision and you're feeling that that conflict is rising, you can ask to work with a mediator. In our firm, we're now offering services that can be done by telephone or teleconferencing like this. So that is one option. Certainly, I want to let people know that mediation is sometimes the most important thing you can do right now, because there really is no other option. You can't march off to court and get a ruling from a judge, not right now. And besides, would you want that? And so offering you the opportunity through Waterstone Law Group to mediate this issue is one way you could do it. You can contact us by email or telephone. But if that isn't something that you need, you might just consider taking a deep breath, letting go of the worry about who's getting what time with the kids, and figure out creative ways to support your children and each other in this stressful time. And that might mean being very careful about your tone when you're speaking to one another by telephone or FaceTime or video conferencing, because when we're not in the same room together, we can't always get the right meaning. Forgive each other if you're misinterpreting one another and there's a sense that one person's making a demand when it's really a reaction to stress and fear. And so give yourselves a break if your communication is difficult in the beginning. Take a breath and commit to just being more cooperative and collaborative in the next interaction. But a quick answer to this question is the children need to be protected from the person who's supposed to self-isolate. And if that hasn't started, it would need to start now.
All right,
Next
so, we received a child support question. Yes, that's my dog in the background. He's not really behaving for the video. So the question was, during this pandemic, while schools are closed, we have agreed to change our custody arrangement from one primary home to equal shared parenting. So before the pandemic, the kids were living primarily in one home, and now the kids are going between two homes. So the question is, what can we do about child support payments while the children are spending equal time in each parent's home?
That's a good question, and there's going to be lots of other reasons for people to make changes to their child support arrangement. So we're going to answer that plus some others in this. First of all, parents need to be applauded and acknowledged for working things out. If you're able to reach an agreement because circumstances have changed, that is the best thing you can do for your children. So if both parties, that is both parents, the payer of child support, and the receiver of child support have agreed, and if you're working with the maintenance enforcement program, then contact your enforcement officer by phone or email, and that enforcement officer can assist you in verifying what your temporary agreement is until such time as you can formalize it, whether it's by a formal written agreement or a variation to your court order. Because maintenance enforcement wants to help families during this time. Now, maintenance enforcement program is also careful that people aren't agreeing to temporary changes or even long-term changes where there's undue influence. And so you'll notice, and I hope you can understand, that the enforcement officer may have other questions besides just the facts and the figures to ensure that people aren't being pressured into agreeing to accept less child support at a time that they might need it. So that's if you both agree, which really does answer that last question. Because if you do not agree, there is another procedure. So normally, the person who's paying child support who needs a change to that support would have to apply to court if it's a court order, or get a written agreement from the other party if it was an agreement, before the collection amount can change. But because of the pandemic, if you're a payer who has suffered a significant change to your income now, and you need a temporary relief that you cannot agree to with the recipient of child support, again, contact the enforcement officer at maintenance enforcement. You'll be required to provide proof of your financial circumstances, but they're making arrangements to allow for this verification to be done electronically. And so a payer compliance plan can be entered into with proof of changed circumstances where there is not agreement. It can be effective for up to 90 days, and the Director of Maintenance Enforcement can extend it if necessary. So while the general rule is you have to get a court order to change it or a written agreement with the other party to change it, in this day, you can contact maintenance enforcement, and the enforcement officer will help you enter into a payer compliance plan. Thirdly, there may be cases where maintenance enforcement is not involved. Many families handle child support and the sharing of expenses directly with one another. And so where both of you agree to change your child support arrangement, then you can do that with your own written agreement saying we're amending our agreement. And you should indicate in your agreement that this is temporary and that it's in response to the COVID-19 pandemic. You should include information that will record what your current circumstances are, that these are the income situations, this is the arrangement for the kids, which is maybe the same or maybe different. And you should include in your written agreement, what are the timelines for this temporary change? When will you review it? What circumstances will lead for it to either go back to the other arrangement or to be reviewed and redesigned? Because what people are often afraid of with temporary agreements is that they won't be able to change them back. So if you have an agreement and maintenance enforcement is not involved, you can handle it fairly, I won't say, well, informally by simply agreeing, but our recommendation is that you write down what your agreement is and you be clear about the timeline, the circumstances for a review, what the incomes are, what the income changes are, and how you plan to address this when things get back to whatever our new normal is going to be. One other point is just that if you're feeling pressured to agree to something, it won't likely be enforceable. And we want to really respect the fact that there are some people who are in situations where they don't have the same freedom to negotiate or the comfort in dealing with the ex-partner. And if that's the case, we'd encourage you to seek legal advice and to remember that many of us in family law will offer help in a way that is true to your budget. There are services out there where we can help you. But if you're struggling with this, you really should seek legal advice. and know that any agreement entered into with undue pressure wouldn't likely be enforced. If maintenance enforcement is not involved and this is a court order, then I would strongly recommend that you do speak with your lawyer to ensure that you record any changes in the appropriate way so that you're not perceived to be breaching a court order. Please know that our courts will be understanding of changed circumstances and that the most important thing is that the children are provided for. So again, I'd invite you to get some legal advice if that's your situation and if you're worried about breaching any kind of a court order, so that we can be sure that you're recording your agreement appropriately. All right, here's another question.
Question 3. So these parents have a court order that gives them shared parenting time. They both spend equal time with their children. The mom will be giving birth to a third child soon. She's working from home, but the dad is an essential worker and has to go out to work. Mom wants the children to stay with her for now to reduce the risk of exposure from dad's work. She's also worried about the risk to her unborn child as well if the children are going back and forth. So the questions were, what happens to the court order? What do they do about it? And what if they can't agree?
Yeah, so this is a tough one, not unlike the first question. We have some guidance from our family court counselor's office at the Family Law Center. And so we're going to start with that because I want to come back to the question about court orders and what to do about compliance. But here's some really great advice that Taylor's going to share that came from our family court counselor's office.
All right. So for those of you who don't know, the family court counselor's office is located in the Family Law Center, and they deal with all sorts of family law issues. They have counselors, they have services they help people with. So their advice, they sent out yesterday, I think. So their advice was to be healthy. The specific guidance of the Chief Public Health Officer and PEI is to comply with all local, provincial, and national guidelines and to model good behavior for your children with intensive hand washing, wiping down surfaces and other objects that are frequently touched, and maintaining social distancing. So all the advice that Dr. Morrison has been giving us all to do, just to follow it as best we can. To be mindful, maintain a calm attitude, and convey to your children your belief that everything will return to normal in time. That's super important, especially as kids might not fully understand what's going on in our world right now. So to explain it at their level and let them know that everything will be fine in due time. To avoid making careless comments in front of children and exposing them to endless media coverage intended for adults. Sometimes it's hard to get caught in a media spiral of watching the news or looking at things on social media. I definitely do it, but to try not to do it in front of the children because it might cause them worry. And at the same time, encourage your children to ask questions and answer them truthfully at a level that's age appropriate. The Family Court Counselor's Office also said to be compliant with court orders and parenting agreements. Court orders exist to prevent endless haggling over the details of time sharing. So even though schools are closed, parenting schedules should remain in force as though schools were still in session. And if your visits or exchanges were supposed to occur through the Supervised Access and Exchange Program, the Family Court Counselor's Office encourages you to contact your lawyer because there are new rules around that.
They also give some other good advice.
They say to be creative. Some parents will have to work extra hours to help deal with the crisis, and other parents may be out of work or working reduced hours for a period of time. Plans will inevitably have to change. It's important to encourage closeness with the parent who is not going to see the children through shared books, movies, games, and FaceTime, or Skype, or Zoom that we're using right now. It's important to be transparent, to try and agree on what steps each parent will take to protect the children from exposure. And parents should be open and inform each other right away if their child is exhibiting any possible symptoms of the virus. Finally, they say to be generous, to provide make-up time to the parent who missed out on parenting time. Generally, judges expect that parents will make reasonable accommodations in situations where it's safe to do so, and judges will take seriously concerns raised in later filings about parents who are inflexible in highly unusual circumstances. So essentially they're saying that the court recognizes that it's an unusual time, and to try and be flexible and creative in coming up with a solution to your issue around parenting. So the Family Court Counselor's Office works out of the Family Law Center. It has various services people can access, so we've included their phone and fax number there, and a little bit about the Office of the Children's Lawyer, which also operates out of the Family Law Center, and we've included their website at the bottom, so you can check them out for some more information about what they do.
We now know, because there's been enough research done studying children who've gone through the separation or divorce of their parents, that they suffer mostly from the conflict and the anxiety that their parents experience interacting with one another. That is the thing that hurts kids. So if your situation does require a change in that one parent is just not going to be with the kids as much, be generous. Use your creativity to find ways, whether it's electronic means or telephone, or if you, depending on the ages of your kids, maybe there's some social media interaction. The most important thing is also to remember that this will pass. That if we follow the rules and the guidelines that have been set out by our medical professionals, we're more likely to get back to normal sooner. And as a parent who now has adult children, we know how quickly life passes when you're raising your children. And the way that you manage the conflict with the other parent at this difficult time will be one of the most lasting memories that your children have about your separation. So be kind to one another. I'm going to go back to the question to see if there's anything else. So what about the court order? Well, you have to firstly put your children's safety at the front. And while we can't advise on specifics, this is the time for you to demonstrate a united commitment to your kids being safe and to being comfortable. If you can't agree, right now your options are to agree, reach out to a mediator who can work with you electronically, because you do not have the option to march off to court to have a judge say, you're right, or the other parent's right. And besides, really, most people don't want that. So if you cannot agree, find some help to agree. The Family Law Center is slowly adapting to this situation so that they can offer some of their services electronically. Those of us in private practice are offering our services electronically, and we want to make sure that families get both the information they need, but also the conflict resolution help that they need. And so in this case, with a mom who's going to give birth soon and a couple of kids, with one parent at home and able to isolate there, and the other parent, thankfully to the rest of us, going out into the world and working, it might be time for a new situation. And if you both agree, the court will be glad that you took care of your family first.
Question 4. If separated parents have no legal agreement in place, what can a parent do if the other parent refuses time with the children? Lawyers are expensive. How is anyone able to afford this? That's a fair question.
Yeah, we wanted to leave in the last one because I think that we have to be honest here. People's circumstances are changing. People are worried about legal fees no matter what. It's why we have created resource packages that can help people figure out what they need our help with and work in the most cost-efficient way. And so one thing to do is to remember that this is a very stressful time. And for people who are already not great at communicating with one another as separated parents, it's likely worse. And so the quick answer is to say, get legal advice to understand your rights and obligations in this difficult time. If you can't afford legal advice, there are opportunities for you to connect with people through the legal aid system and through the Family Law Center's services to parents. And so I'm going to encourage you to reach out to those services. if you want legal advice and or conflict resolution services, most lawyers are working remotely and able to respond by email or telephone. And certainly when people are worried about legal fees, I think the most important thing to do is make that clear in your inquiry, so that, for instance, when we get an inquiry from someone who has a very limited budget, we have a process in place to ensure that the information gathering is reduced in time so that our fees can be kept down and very much focused on the pieces that these parents need help with. Otherwise, that second line is a hard one when people are worried about their own livelihoods. So I guess I can encourage you to reach out to firms like ours, where we want to be transparent about how we charge. See, there's the phone ringing again because people have questions. And then if the other parent refuses and you have no other recourse because there's no written agreement and there's no court order in place, it may be that this is the time to accept that maybe there's nothing you can do, and know that in 2 weeks or 4 weeks or 8 weeks, there might be a service available to help you. And that's sad and difficult, but that might be a reality.
Okay, I'll read the situation first. Parents have a temporary parenting agreement, which is reintroducing the children to a parent who was less involved in the past. Over the past 6 months, the non-custodial parent, so the parent that the kids weren't living with, has spent time with the kids once a week and every second weekend. The kids are slowly getting used to this, and there's hope that the less involved parent will be a consistent part of the kids' lives from now on. Conflict between the parents means they cannot interact or communicate, so both sets of grandparents are helping with drop-off and pick-up, and it's being done at a public place. The custodial parent, so the parent that the kids are living with, is currently self-isolating with the kids as they returned home from PEI from a trip. Those 14 days will be up soon, so it'll go from self-isolation to social distancing. The questions are, can the custodial parent suspend the visits with the other parent for the duration of the pandemic? And are the grandparents being compromised by continuing to do the transportation for pickups and drop-offs?
Yeah, so talk about an important community question. I want to start with the grandparents and give a big shout out to the grandparents that I know and that I know through our law practice are supporting their kids' kids. It's huge. And so depending on the demographic, we have some grandparents who are helping, who are within the vulnerable age group. And so I think it's clear that grandparents who are assisting with transporting from one home to the other cannot possibly be social distancing with those children in those interactions because of the nature of a vehicle. I guess it's different if you're walking, 2 meters apart. I mean, this is not easy. And so if parents who are worried about this situation could take a step back and think about the grandparents, that might help. And grandparents, you have to follow the rules too. And so unless you're living with these children, it isn't possible really for you to do the transportation without breaking the distancing rule. So where does that leave this? The conflict between these two parents, is significant enough that they're now subject to a stay away order and they're not to communicate or interact. And so this is a difficult one. It looks like this is a situation where they've got an agreement in place, but not a court order. But whether it's an agreement or a court order, there will be practical situations that prevent people from transporting the kids from one home to the other. And that might just have to be a reality for a while. There are other ways to manage this if both parents agreed. And I think that given the stay away order, the only way that you could work towards an agreement would be to either have each of you represented by lawyers who can help you sort something out, or depending on the level of conflict and the appropriateness, mediation might work just to work something out. And to remember that in this situation, it sounds like the kids are reestablishing a relationship with a parent who was not really that involved, and that it's going well. So maybe the focus should be on demonstrating to those kids that they're number one, and that the parent who's coming back into their lives might find a different way to interact with them using the electronic means. You know, there's a number of examples of parents or aunts and uncles or grandparents getting on Zoom or FaceTime or even just the telephone to read the kids a bedtime story, or to spend an afternoon watching a movie together. And so remembering that being physically in the same room isn't always required. We're all missing the people in our lives. I'm happy that I can see Taylor's face in this video screen, because not only is she my colleague, but she's my daughter. And we're physically distant because we're following the rules. In separation and divorce, there can be a sense that your children are more vulnerable because they don't have the family all in one home. And I'm going to reiterate what I said earlier, and that is that children who feel free to love both of their parents and who feel loved by both of their parents, they thrive. Children who experience their parents fighting or fighting over them or blaming one another, arguing, diminishing the role of the other parent, those are the kids that suffer. So don't make that your kids. In this case, if the parent who has been the primary parent for a long time makes the judgment that the other parent's parenting time needs to be suspended for a while, the other parent might just consider that the parent that's been involved from the beginning might have a better sense of what should happen next. And if it's a fight, maybe just stop fighting. We're in a global pandemic. People are dying horrible deaths far, far away from their loved ones. And so I think you can do this.
Okay, question 6. So, child protection became involved this winter and imposed conditions on this parent's parenting time. The parent had been having supervised visits with the child before the pandemic hit. The parent's now clean and sober and has been following all the advice of child protection, but now counseling has stopped, which I'm guessing was one of the conditions. Child protection says that everything's on hold during the pandemic, so this parent hasn't been seeing their child. They're worried as no progress is being made with their case, and they really want to see their child, and they've been working really hard to better themselves, and they feel like they've been treated unfairly. So their question is, what can they do?
So the person who sent in this question is doing all this work to be able to be a parent. And that is to be acknowledged and applauded. But I'm sorry, this isn't about fairness. So what's happened is a lot of people who are dealing with their own personal challenges, whether it's mental health or physical health, and they're working in a system where the role of the child protection workers is to protect the children, can often feel that they're not being treated fairly, and that is a very difficult thing to accept. But we're in a pandemic where everyone who's got a job to do is trying to do it. So one thing that you can do if you're working hard on clean and sober is just keep working on it, knowing that your goal is to be a good parent to your child, and that that child will still be waiting for you when this begins to pass. Notions of fairness can really get in the way of healthy discussions. And so think about the child protection workers who still have to manage families from a distance and have a limited ability to really provide the support that families need, and they're doing the best they can. So if you have a legal question, consulting with a lawyer could help you. If you have a question that has to do with the system, that is the child protection system, I'm afraid you're likely going to have to wait until that system's able to handle your case. Because once there is a child protection concern, you have to let that follow through. So keep up the good work dealing with your addiction and whatever your challenges were, and know that I think, despite it being not a perfect system, the system's there to make sure that you and your child are reunited, and that now might just not be the time that everything can act as quickly as you want. Sorry, I think that's all I got on this one. But really, really great to know that you've taken the choice to make your child the focus of your recovery, and remembering that now might be the challenge to you to make the goal of your recovery also about you, and making sure that you're well enough to step into that role when this passes. All right.
All right. Seventh and final question for this week. So they're leaving a difficult marriage but wanting to work things out. There was some domestic violence and they eventually decided to end the marriage. The parents are living in separate homes but have not yet worked out a parenting or financial arrangement. The physical and emotional abuse has occurred in front of the kids in the past, but the behavior has improved since separation. So the questions are, despite the difficulties and the abuse, both parents want to work things out as easily and cost efficiently as possible. How can they do this, and what are the next steps?
So we didn't make this stuff up, people. All these questions came in, but actually the answer to this question will in many ways highlight the way we work at Waterstone Law Group. So I want to talk about that. The important thing about this question is that the person who sent it in has come out of a very, very difficult domestic family situation. And because things have improved after separation, this person feels confident that they can work things out with the former partner. And that means that mediation might be appropriate. The other way to approach it, particularly where there are still challenging behaviors, is to look at collaborative practice and the way that couples can work with each of you having a lawyer, so an advocate to help you and guide you, but with a commitment to working things out. In collaborative practice, you can also bring in the wisdom of other team members. So you could each have a lawyer, and there could also be a family counselor working with the two of you or with each of you separately to help you get past the challenges and the challenging behaviors from before and improve your ability to co-parent going forward. And so, because the question is about what can you do, I'm going to focus on that. But remembering that wherever there's situations with domestic violence in the home, children are affected even if they don't see it. And so you have to work even harder to make sure that those children get information and comfort knowing their parents are going to interact with each other in a different way in the future. And so your case isn't an easy one, but your desire to work things out will take you a long way. What collaborative practice brings is the opportunity to have each partner, each spouse, having a lawyer that's committed to helping you work things out, but also bringing in these other team members to help make sure in a cost-effective way that the person with the skill set that you need is the person helping you out with that piece. And so as an example, if you needed help with a parenting agreement, you might each have your collaborative lawyers in place, but the family counselor would be working with you on developing that parenting plan. You'd still have the guidance and advice of your lawyers, but you'd be doing the work with someone who went to school to help families from a counseling perspective. If you're struggling with financial decisions in collaborative practice, we can often bring in a neutral financial professional who can look at the financial situation and help in a way where it's not one person arguing one way and the other person arguing the other. So you've got someone who's focused on the unique needs of your family. We also, because at Waterstone Law Group, we work with families of all kinds, families with a lot of resource and families with limited budgets. And so that's why we developed our resource packages, so that you can work with us in a way that you leave with guidance, homework, even a workbook, that you can be doing some of the work on your own time, on your own dime, but guided very specifically by us as your lawyers or as your mediator to address the legal, practical, emotional, and financial pieces that you need. And so a lot of people who are ending a marriage think of television, or they think of the Netflix movie Marriage Story. Don't be that. If you really want to work things out, make sure that the lawyer or mediator that you choose is interested in helping your family make a healthy transition to two homes, and doing that in a way that respects your budget, but offers you the level of service and advice that you need. Because not everybody needs their lawyer to handle everything. Some people need us to handle everything. And when I say handle, I mean work with you to help resolve everything. And so pick your lawyer, mediator, or collaborative professional carefully. And it's not uncomfortable for us to have that conversation about costs and budget upfront. Because we know, like the question from earlier, we know that people come to see us worried about what it's going to cost. So what we try to do is be as transparent as possible and build in cost efficiencies by guiding you in some of the work that you can do at home. So for the person who sent in this question, I applaud your desire, and I hope it's shared by your partner, that you find a way to work things out in a respectful way that ensures your family has the healthiest future. So I think that's question
Last
7.
question. Yeah.
What's the next slide? How to contact us. So basically, you heard from the beginning, we're doing this because we're members of this community on Prince Edward Island, and we want to help. So if this general information isn't enough and you're looking for legal advice or conflict resolution help, contact us. Or check out our website. You'll see our resource packages are all listed there. We want to help families in Prince Edward Island through this very difficult time. Thanks to everyone who submitted questions. We'll be back next week. In the meantime, stay safe and remember, we're all in this together.